Okay, well, I think any updates to Zoom are either still happening because it's been a long time, or everybody's joined, and I'll speak a little slowly to give another minute or so. But I wanted to welcome everyone to our ABC Western Michigan Informing the Industry webinar on the paid sick leave and minimum wage changes. We're joined with the experts from Hilger Hammond. There's significant cost changes that will be impacting members and those of you who are not members of ABC on here. And so we wanted to provide a webinar to educate those of you attending today, and then something to record to send out to those of our members as well. ABC is actively advocating for changes to this law, so we hope we'll have another webinar with Hilger Hammond to have some updates and changes. But right now, we want to tell you where things are and how you can start to begin to comply with this new law, which takes effect next year. I'm going to post about what ABC is advocating for. You can find it on our blog, on our website under the Inform tab, but I'll send a link in the chat here shortly. If you have questions throughout the webinar, please feel free to type those into the chat, and either the Hilger team will address that as they're going or take time at the end to answer those questions. If not, perhaps follow up with those of you later. So again, let me introduce the Hilger Hammond team of Ron Reynolds, Jill Miller, and Jeremy Orenstein. Go ahead and take it away and share your screen and begin presentation. Thanks so much for presenting to us today.
Thanks, Greg. I'm Ron Reynolds. Jeremy Orenstein is with us. He's a litigator at our firm, and Jill Miller, who I think many of you may know, is in our business group at Hilger Hammond. I do litigation, including employment litigation, and we are going to tell you what we can about the most recent Supreme Court decision affecting both minimum wage and earned sick time. Jeremy's going to start us off. Maybe. We can, there we go.
There we go. All right, so just a brief background of kind of how we got here and what leads us to where we are today. So for those of you who don't know, under Michigan's Constitution, citizens of Michigan have what's called the initiative power. And citizens or group of citizens can either propose a new law, approve or reject a current law that's already enacted, or also amend the Constitution. In order to have the initiative petition, it requires signatures of 8% or more of the voters cast in the most recent gubernatorial election. So if 8% or more of the signatures are gathered, the initiative moves to the legislature. So once the citizens get enough signatures, they get the petition, it goes to the legislature. The legislature then has three options to decide on what they want to do with that initiative. Those three options are the legislature, once they receive it, within the first 40 days of when they receive the initiative, they have 40 days to either enact the initiative without change or amendment. So the legislature just gets the initiative within that 40 days, they enact it, it becomes law, everything's kosher. The next thing that the legislator can do if they don't want to adopt the initiative as proposed, they can not adopt the initiative or reject it, in which case the initiative actually goes onto the ballot to allow the voters to vote on whether it should become law or whether it should just, die on the ballot. The third option is the legislature can reject parts of the initiative and amend or propose different measures in the initiative. And if the legislature decides to go that route, then the original initiative as proposed, as well as the initiative as amended by the legislature, actually goes onto the ballot to allow the voters to vote on either the original or the as amended one by the legislature. So if we fast forward to 2018, and 2018 citizens from local groups submitted initiative petitions to the legislature in September of 2018. Those petitions were the Improved Workforce Opportunity Wage Act, which proposed significant changes to Michigan's minimum wage and overtime laws, which we'll discuss later in this webinar. And along with that proposal, the citizens also proposed the Earned Sick Time Act, which we will also discuss. So in September 2018, the legislature received both of these initiatives and they adopted both of them. So they enacted both initiatives into law. So in November 2018, when the general election happened, the initiatives weren't on the ballot. They weren't voted on by the voters because the legislature adopted them. And as one of the options that the legislature can do, everything seemed fine. After the November 2018 general election, the legislature actually amended the initiative. So they adopted them as proposed in September 2018, waited for the general election to happen. And then after the 2018 general election, they amended the initiatives, and that really changed what the proposals were. We'll get into what it was as proposed and what the legislator ultimately amended. But this came after the general election, and as we know, that's not one of the options that the legislature can do. So following the 2018 election, Mothering Justice, which is Mothering Justice versus Attorney General, these citizens brought an action against the state of Michigan and the Attorney General, basically challenging the legislature's decision to adopt and amend post the 2018 election. And then after 6 years of litigation, the lawsuit ultimately makes its way up to the Michigan Supreme Court, in which the Supreme Court issued its opinion on July 31st of this year. And a 4-3 decision, so it was a split court that that held that the adopt and amend that the legislature did in 2018 within the same session was unconstitutional. And so adopting and amending within the same session was held unconstitutional. So the Supreme Court said the as proposed initiatives from September 2018 are the law that's going to go into effect. So what does that mean? The amendments were held unconstitutional and struck from the initiative, and that revived the original initiatives as submitted. The Michigan Supreme Court, in what can only be described as an unprecedented fashion, enacted the initiatives as proposed rather than submitting them to the voters to vote on. So nobody's voted on either of these initiatives. And because the initiatives were from 2018, there were schedules that were supposed to take place starting in 2019 of the minimum wage increasing every year gradually. And so the Supreme Court took that into account and said that this gradual change will start happening February 21 of 2025, and that will carry through 2030 until everything is where it needs to be.
Jill Miller is going to talk about the changes in the minimum wage that were as a result of the Supreme Court decision.
And then there was some later clarification last week on how we're going to calculate all this. So where are we today? Today, the current Michigan minimum wage is $10.33 per hour for regular employees. Just for perspective here, the federal minimum wage is $7.25 per hour. All right. Jeremy's summary, I'm going to give you where we were and would have been had certain things happened in 2018 that he discussed. So that original voter initiative that we talked about in 2018, which never made it to the ballot, had that either been adopted as it was proposed or made it to the ballot and voted in, that would have increased the minimum wage gradually to $12 per hour by 2022. The legislative amendment, this unconstitutional adopt and amend that happened later in 2018 after the November elections, that would have increased the minimum wage gradually each year, and we would have been at the same place by 2030. So that would really spread out those increases. All right, so where are we today and what do you need to be prepared for? Today, as of July 31, the Improved Workforce Opportunity Wage Act is valid. It will become effective February 21st, 2025. This is what you can expect. Again, today we're at 1033. Come February 21, 2025, we'll be at 1248. Then again, in February of 2026, we'll be at 1329. In 2027, we'll be at 1416, and then we'll be all the way up to 1497 by February 21 of 2028. That's a 45% increase over 4 years. And then what happens in 2028 and beyond? Beginning in November, every year, this state treasurer will calculate an adjusted minimum wage. It'll be based on inflation. They'll publish it by November 1st, and then it will become effective January 1st of the succeeding year. So that's what will happen starting November 1 of 2028. Let's hit the next slide. I'm going to discuss a little bit about tipped employees, although probably not as relevant here in this situation. Today, tipped wage phase out employees, we're currently at 38% of the regular minimum wage, and we're going to phase that out through 2030. So in 2025, a tipped employee will make 48% of the regular minimum wage. In 26, they will make 60% of the regular minimum wage. 27, 70%, 28, 80%, 29, 90%. And then in 30, they'll be at 100%. As you know, there are groups that are advocating against this one as well. And we're going to monitor what goes on to see if the legislature, the government, makes changes to this, proposes changes. We'll keep you abreast. We'll post it on our website, but we're going to be watching. I'm not aware of anything right now. Ron, are you?
I think just like Greg indicated that ABC was, you know, lobbying. I know that the Michigan Restaurant Association is actively lobbying on behalf of their members also. There's it doesn't affect your businesses directly, but it affects all of our pocketbooks for anyone who goes to a restaurant. Sure.
Yeah, yes. And we wanted you to have these numbers just so you're prepared over time for these changes and your budgets as far as your workforce.
So I'm going to talk about the Earned Sick Time Act, which is as the original initiative as it was proposed and how it's been enacted by the Michigan Supreme Court. There's a lot of meat to this. I have a number of slides. I'm going to try to move through them and focus mostly on the most important information for you. And if we can, we'll address questions. But if you have questions about this, at the end, you'll see our emails. You can probably reach us through Greg if necessary. We're happy to try to help you out with more questions. I just wanted to give you a warning. There's a lot of information coming at you right now. So the ESTA, as it's affectionately referred to, the coverage applies to all employees. It's going to impact all of you who are on this webcast, and includes both exempt and non-exempt employees, full and part-time workers. And it expands the permitted use for sick time, for what you can use sick time for. Very broad definition of employee. An eligible employee is an individual engaged in service to an employer in the business of the employer. So expect some litigation down the road about independent contractors and things like that. And certainly the Act expressly addresses seasonal employees and part-time employees, and they do count. So again, under coverage, businesses with 10 or more employees, you're going to have to start providing 72 hours of paid sick time per year. You can do that in however you keep your leave, whether you do it on a calendar year or on a fiscal year, you should do it the same way. Under the prior act that was amended by the legislature, that was a limit of 40 hours. So that's a significant add. It's almost 2 full weeks of sick time, 72 hours, you're 8 hours shy of 80 hours there. So I guess it's 9 days of sick time, basically, if you're talking about 8-hour days. There is special rules for smaller businesses with fewer than 10 employees. They only have to provide up to 40 hours of paid sick time, plus an additional 32 hours of unpaid sick time. So smaller employers do get a break. But employees have to be able to use their earned sick time before using, their paid sick time before using unpaid sick time under the Act. The test for whether you meet the 10 employee threshold is if you employ 10 or more employees in 20 or more work weeks in the current or previous calendar year. That includes full-time, part-time, temporary. including temporary service or staffing agency employees you use. And the 20 work weeks need not be consecutive. So you're gonna have to have, someone in your offices who's keeping track of, if you're close, if you're on the cusp, you're gonna wanna have good documentation as to whether or not you fall under the 10 employee threshold if you're trying to remain a small business. Once an employer meets the 10 employees threshold, coverage remains through the current year and the following calendar year or fiscal year, depending on, I guess, the following calendar year here. And it would just depend on where your fiscal year falls in it. Okay, how do you accrue leave? How does an employee accrue leave? The accrual rate is 1 hour for every 30 hours worked. They didn't make it 40 hours work. They didn't make it something easy to calculate. So it's 30 hours. I don't know too many employers who put their employees on a 30-hour work week. And you can earn up to 72 hours, but that is, when you do the math on that, an employee would have to work 2,160 hours a year in order to meet 72 hours. So right away, a lot of employees will not accrue necessarily 72 hours, but eventually, because as we'll talk about as we move on, it rolls over automatically. They'll eventually have a 72-hour bank if they're an employee of several years for certain. Accrual is going to begin on February 21st, 2025, or upon the start date of any employees you hire after that. There are special rules that relate to an employee who has left your employment but returns within 6 months. So be wary of that. If you're rehiring employees, check into what you may have to do. They may come in with a bank of earned sick time already. This next bullet is what I just kind of hinted at. It can be carried over, but they can use no more than 72 hours in any given year. So employees who don't use it, it'll continue to bank, but even if they bank over 72, they don't get to use more than 72 in any given year. And if there are some things that some employers, especially smaller employers, may decide, I don't want to hire an entire new HR person just to handle earned sick time. So you may try to adopt some procedures that make it simpler to comply. One of them might be just front loading the entire 72 hours at the beginning of the year and letting them take it right away, as opposed to having someone calculate the 30 hours and as to each individual employee you have. Importantly, I'm surprised this made it in, but you do not have to pay for unused accrued earned sick time when an employee is terminated. I say I'm surprised that made it in because I'm pretty confident that there were no employee stakeholders involved in drafting this initiative. You can tell that just from reading it. It's a very pro-employee initiative. And it's no doubt going to cause a few more gray hairs for those among us who deal with these issues. Many reasons, very broad reasons that you can use your leave for. The employee's own mental or physical injury, health condition, etc. The employee's family members' mental or physical illness, and etc. So that expands it beyond, now you can take sick leave for if your wife's sick and you say she needs my help. There are special provisions for victims of domestic violence and sexual assault, including time off to be relocated if you need to be relocated or to obtain legal services, attend criminal proceedings, and the like. You're able to use this leave to attend a child's school or place of care related to a health or disability, or related to domestic violence or sexual assault of the child. And then the next bullet point is what I call the COVID-19 provision, which is basically if there's a pandemic or a public emergency, employees are allowed to use this, if they are having trouble finding childcare, if schools are closed, things like that. Importantly, an employer shall not require an employee to search for or secure a replacement worker as a condition for using earned sick time. Okay, I throw this out there just as comparisons for those of you who follow who are eligible for the Family Medical Leave Act. Note the limited reasons that you can use, FMLA for, which, as we all know in practice, is very broad. Can be very broad, especially when you're talking about and record keeping and obtaining medical records and things for employees just with the FMLA. It can be a full-time job for somebody. So those are the 4 categories for which you can use FMLA. Obviously, ESTA expands and gives employees many more reasons that they can use sick leave for. This, I'm sure, will excite everybody. Family member seems something that we all know what it means, right? And they define it for us: biological, adopted, foster child. These are things that we would expect. Biological parents, step parents, etc. Guardians. If you're a guardian of someone, that's going to count. Your grandparent, your grandchild. So these are all reasons that if your grandfather's in the hospital, you can take a day off if you say that they need my help that day. And trust me, it's not going to be easy to challenge the reasons for someone taking something off. This is a very pro-employee law. Biological, foster, and adopted siblings. Here's the one that I think is the most stunning. Any other individual related by blood or affinity whose close association with the employee is the equivalent of a family relationship. I understand what related by blood means, but I'm not exactly sure what related by affinity is. And that's gonna be one of those issues that you're gonna see the Department of Labor and Economic Opportunity probably give some guidance on, and probably we're gonna see some lawsuits about that with people having very creative family members. So just that's probably the most kind of ambiguous clause in the entire act. Okay, leave increments. You can your leave increments is the smallest amount of time used by your payroll system for absences or use of other time. So typically, that might be a half a day or a day. However, if you do a precise increment of time for these types of absences, for example, if you use the 1/10 system, I'm not aware of any of my clients that do this, but then you would have to use that same increment. So keep that in mind if you use a precise increment for granting leaves and sick time currently. Does the employee have to give you notice? Well, technically, yes, but in practice, maybe not. If it's foreseeable, they're required to give you 7 days notice of the need for time. However, if it's not foreseeable, they are to give you notice as soon as practicable. So the question becomes, what's foreseeable and what's not foreseeable? And do you really want to get into a fight over whether it's foreseeable or not? You may be having employees, call you the morning of, and on something that you would consider completely foreseeable, but you probably don't want to litigate that. It's just my advice, unless you've got an employee who is just that is a recurrent abuser of this policy. You can require documentation. For earned sick time of more than 3 consecutive days, an employer may require reasonable documentation. The employee must provide this documentation in a timely manner. Again, another vague term used in this act. What does timely manner mean? There are limitations on what cannot be, what should not be in the documentation. And if your request for documentation requires them to go see their doctor and they incur a copay, you just incurred that copay under this act, just so you know. And by the way, while you're waiting for the documents, you can't delay the leave. so they get to go out on leave. If you do receive documentation, you must maintain the confidentiality of those documents. Kind of like a mini HIPAA provision, I suppose. But I can tell you that some clients that I've talked to are considering not requiring any documentation just because of the hassle of keeping the documentation. It does invite abuse by those employees who figure out how to game the system. But if you have, most employees are probably not going to game the system. And from a standpoint of record keeping and personnel, the use of your administrative team, it may be something you want to consider, just saying, you're good. Record keeping, the record keeping of the accrual of time and any documentation that you receive, you need to keep for not less than 3 years. And if for any reason, if a complaint is made to the wage and hour division, they are able to ask to look at your records, and you have to produce them at a mutually agreeable time. Okay, so we're moving pretty quick, I guess. So here's something you want to consider. You can coordinate your ESTA time with other leave time. The Act says an employer is in compliance with the Act if it provides any paid leave in at least the same amounts as that provided under ESTA. That can be used for the same purposes as those conditions provided in ESTA, and that is accrued at the rate equal to or greater than the rate described in ESTA. If you do this, and paid leave includes paid vacation days, personal days, and paid time off. So a consideration you're going to want to take into account is whether or not you just push all your PTO, vacation time, ESTA time into one bucket. It has to be more than 72 hours. Well, it has to accrue it at least at 1 hour for every 30 hours worked. Again, as far as timekeeping and personnel use of your administrative team, it might just be easier to give everyone 72 hours in a bucket, or if you typically give them a couple weeks vacation, maybe you give them 3 weeks in a bucket and say, this is your, whatever works for your company. Obviously, it's going to be different for everyone, but here's your sick time, paid vacation time, personal time off time. So there is a way to administer this and keep your paperwork and your administrative team's time down to somewhat. That may not be practicable for your business, and you may have to dedicate someone to keeping records and doing it in a way that is best for your business. That's obviously going to be a business by business decision. Okay, not surprisingly, there are pretty strong remedies available to employees for any violations. They can file a complaint with the wage and hour division, and they make that pretty easy by having an online complaint form. They can bring a civil action. But importantly, you need to know about this presumption of retaliation. Employers may not retaliate. Okay, we know that. Retaliation is not good. For engaging in protected activity under the Act. Importantly, there is a rebuttable presumption that an employer violated the Act if it takes any adverse personnel action against an employee within 90 days after the employee engages in protected activity. So think about that. It's a 3-month window that they've asked for time off, they've taken time off. If they're terminated for any reason, you now are going to have to be able to prove that you didn't retaliate against them because of their exercise of rights under ESTA. That's as strong a protection I've seen in any of these acts, and that underlines what I said earlier, which is there weren't any employer groups involved in drafting this. And of course, if they file a court action like a lot of other, like under the Civil Rights Act and other acts, they can be awarded attorney's fees and costs in addition to any damage they may recover.
And I'll add, excuse me, that this rebuttable presumption really raises if we've talked about record keeping and documentation, and everything, in the sense that you want record keeping and documentation to comply with the act. You also want record keeping and documentation of, like employee reviews and things like that. So, because, in theory, an employee could take a sick day every 3 months and then be protected by this rebuttable presumption. And so, in theory, the employer may not ever have a basis for firing the employee if the employer is scared of this rebuttable presumption. But it's important that you keep documents and records of, things that maybe the employee is doing poorly, or your employee reviews or things like that, so that you have documentation to support and rebut the presumption that arises under this act.
And if you also have a policy where you don't ask them why they took their leave, that then kind of, it's gonna insulate you a little bit, because you can say, they took leave, I had no idea if it was under the act or not, right? It could have been a paid time off day. Jeremy is correct. Documentation is the employer's best friend. Also, I know in your industry in particular, and a lot of industries, it's also one of the hardest things to do, right? You're building things, you're in the field, things happen in the field. I'll get to that, I'll write it down later. If you can train your people to document early and often, that's your best friend. And I've defended a lot of employers, employee terminations, and the quality of the documentation is always one of the key issues in the case, just so you know. So the Department of Labor and Economic Opportunity, by the way, when the name of that department, I'm not sure they're talking about an employer's economic opportunity when they named that department. But they have issued a poster, you can find this on their webpage, that you're gonna have to post with regard to ESTA and informing your employees of their rights under ESTA. We are gonna have some time to address some of the questions. Can you pull up the chat? Oh, I'm sorry. Here's some important takeaways. Review your employees' sick time, leave, PTO, vacation time, FML policies, and consider coordinating them as appropriate for your business. That'll be, like I said, that's going to be a business by business decision. Currently under FMLA, the best practice is to say, if you take FMLA, you have to first use up your leave time. And so you're probably going to want to do that, at least have that consistent across your policies. Can't stress enough, adopt good record keeping practices. If you are in court ever, that's the one thing I can tell you when I sit down and talk with clients. Oftentimes I hear, we should have had better records on this. Things that they know happened aren't even recorded somewhere. That can save you. And also importantly, whatever practices you adopt under ESTA, make sure you adopt them with consistency as to all employees. You can't favor your favorite employees over you can't treat them one way over another. That's a sure way to get yourself in trouble, because typically the employee who's the problem employee, if they don't know how to game the system, they certainly know that someone else is being treated differently, and then they're going to find some other reason why they think that is, and then you might end up with a Elliott Larson claim against you.
And Ron, also with the consistency piece, I think with the documentation, you may have one employee who you really don't trust, but you certainly can't require documentation from the one employee, not from others.
On ESTA?
When we were talking about that jumps out with me, and to me, and you and I talked about that. It's so important, if you're gonna make a blanket policy, that you apply it consistently to all employees.
Right. I have my own small firm once, and when you have good employees, you feel like, well, there's no problem here. And then you get one person where you have to keep an eye on, and your tendency is to kind of like require different things out of that employee than out of the rest. And that can get you in trouble in court. So at least you need to have the appearance of consistency across everything. These are our emails. I don't know if Greg can make those available, or you could just reach any of us at hilgerhammond.com easily enough. But we're gonna see what, if any, it looks like we've got some chat activity out there, and we'll see what we can answer. we pay out balances at the end of the year, or do you have to carry over? That is not addressed in the legislation. That's an excellent question, and I've sat in on a couple of webinars, and that question hasn't come up, so Krista, excellent question. I'll tell you what, I will look into that for you and try to get an answer to you, if not directly through Greg. Yes, Krista Richmond.
Yeah.
Pay out instead of carryover. I'm sure your employees would be happy if you paid it out.
Are we able to get a copy of the presentation? Yes, I believe Greg is recording this and then we'll provide it to all the members who are in attendance.
And hello to Heather, how are you?
Are you allowed to not have carryover if you do a payout?
Okay,
each
same
fiscal year?
question. We're gonna try to, we'll look at and get, the best answer we can on that, and we'll give that to Greg, and maybe he can post that for us somewhere.
What if we currently offer 80 hours vacation time per year? Does the 72 hours maximum use still apply, or can we just gift the rest as vacation and let employees have more time off?
No, you can you can go higher than the 72. That's one thing the act said. So you have to do a minimum of 72. So that'd be a perfect way to do it. Take your 80 hours vacation time and call it leave, ESTA, sick time, personal time off, bereavement, whatever. Throw everything in there you can. And they got 80 hours.
And paid holidays count toward the 72 hours.
I do think that this is, no, I think they have to be hours worked, but I will double check that. I do remember, I do believe they have to be actual hours worked. So, but I will double check that to make sure I'm accurate on that. See, I might go back to that slide because I think the accrual slide. Okay. Yeah, the statute says 1 hour for every 30 hours worked. So a holiday would not be a day worked.
So for part-time, do they get the percentage of hours that they actually work? If they work 20 hours per week, will they get only 36 hours per year?
They would get, so let's say after 3 weeks, they would get 2 hours. Yes, so I didn't do the math out, 36, assuming you're correct. Yes, only for hours worked.
What questions are we allowed to ask our employees related to taking sick time? Can we ask them for a reason legally?
Yes, but let me go back to what you can ask them about. You cannot ask them, I should say. There, you do have to be, you can't. That was the slide that had the confidentiality on it.
Yeah.
So the statute says documentation should not include a description of the illness or details of the violence. So I think you can ask them, and you can ask them to get documentation. But you're going to want to tell them that you can ask them, but you don't need to put the reasons in the documentation. You're just, for example, let's say your employee is going to court because a relative was engaged in a domestic violence incident. Something that shows that they were at court. Yes, you can, but you are getting in a tricky area there. That's the area where it's gray, and that's where you're going to find probably guidance coming out from Leo and other organizations as to what you should not do. And again, this is one of the probably most liberal leave acts for employees in the country, and we're going to learn as we go, quite frankly, and hopefully not by being sued.
And it's important to keep in mind that if you're asking for documentation and things like that, that you as the employer are responsible for paying those out-of-pocket expenses for the employee obtaining that documentation. Next, how do we track records of ESTA time used if we coordinate it with a vacation policy?
If your policy is over 72 hours, you don't have to track it. You can just tell people you'd use these for sick, vacation, whatever you want to use it for. As long as you are 72 hours or more. Or I shouldn't say that. It's not the number 72. As long as you are accruing at 1 hour or 30 hours worked, and banking it that way. Then you don't have to, that's one way you don't have to keep track of it, is to say they can take it for whatever reason they want.
Can paid time off be taken immediately upon accrual of the first hour?
Yes,
When you have a new hire, does the sick time accrue when she meets the probationary time or from their hire date?
yeah, there's a good question, and I'm surprised that was not on one of my slides. For new employees, I thought I stuck that in there. For new employees, you have a 90-day probationary period. And I will check on whether it accrues. I do believe it accrues during that time, but you don't have to allow them to take it within the first 90 days. And I'll double check that and make sure I'm accurate on that. But it does accrue.
What if a part-time employee works such a limited schedule that they don't accrue 72 hours annually? Are they still required to receive 72 hours?
No, only what they accrue.
If we have part-time employees but grant all the PTO as a front load after a probationary period, do they have to also be granted 72 hours like the full-time people?
Well, that's creating, with part-time employees, you may want to accrue because, or you just might want to assume they're gonna, if your part-time employees are gonna, first of all, they're not gonna hit 2,160 hours, right?
Right.
So with part-time employees, you just want to make sure that whatever you're granting them meets the hours worked requirement.
1 hour.
So you might want to say, we're going to front load you 36, and if you've got a part-time employee that all of a sudden is working a lot of hours, you may have to keep track of your part-time employees and make sure you're complying with the act.
If we front load 80 hours of PTO, but have a 90-day waiting period for use by new hires, would that be compliant, or do we have to allow use right away?
That specific question is obviously not addressed by the legislation itself, the initiative. What you could do is grant them a portion PTO and then bank the rest after their 90 days. Yeah, so that's a question that is not directly answered, and I have not seen that in any guidance from Leo, or have I seen that discussed by anyone? But I do think there's a way you can do that if you do decide to front load.
Next one is, how does this work with salary employees?
Technically the same way, except what I've heard in other discussion groups is, I think a lot of employers are planning on just front loading their salary employees. Just because they don't want to keep track. You typically don't keep track of your hours worked for your salary employees. If you are going to use accrual for them, then you're going to have to start keeping track of their time.
Can we have a requirement that they must use in full day increments? Half day, are we forced to track 1 hour here, 1 hour there?
You can make them take it in the same increments that you use for other leaves. So if for example, your PTO policy is they have to take at least a half day, you can have them take at least a half day under ESTA. That creates a problem, obviously, if they don't have the hours banked. I did want to also note, there is no protections in the Act for an employee who has exhausted their 72 hours. So there is the potential that someone is going to exhaust their 72 hours. and not have any other leave under your company policy available to them, and they're gonna be sick and out. And you know, you're probably you know, you're risking the presumption issue of the 90-day, you know, presumption that you gotta prove it wasn't related to ESTA. But you know, in typical, typically employers terminate people for not having time off and who are not showing to work, so.
Do seasonal employees receive sick time?
Yes. All employees count, so you're gonna have to track for them.
Thought that we had to keep records of accruals and used for 3 years.
If you front load, then you're just saying they accrued on day one. So that's your record, right? But if you are going to make them, if you're gonna give it to them as they accrue it, then yes, you have to keep records and have those available for 3 years. You're also gonna wanna keep all your records with respect to use. Anything having to do with ESTA, you're gonna wanna keep for 3 years. But if they were to say, what's your record that you gave Joe Smith his hours, you're gonna say, on January 1, we gave him 72 hours of leave. So that's how we know that he accrued on day 1.
If someone works 50 hours in a week, do they only earn the 1 hour or would they earn a partial hour?
They would earn 1 hour for the 30 and whatever, and 2/3 of an hour for the other portion.
If staff are hired mid-year, is the 72 hours prorated based on hire date?
Yes. Prorate, well, that's when they begin to accrue. Oh, so if you're gonna front load, I see what you're saying. Yeah, if you can figure out that you could prorate it. You just wanna be careful and you wanna keep an eye on that employee and make sure that they're not like billing so many hours or working so many hours that somehow they get above what you gave them. Because that can cause you a problem. There are fines, the fines they're like $1,000 fines and things like that, but there's also this whole thing of you know, being sued and having attorney's fees paid. So you wanna make sure, and there's gonna be special situations. Not every employee is gonna fit in the box. And with those special employees, you're gonna wanna take time and make sure you're doing it correctly.
Are you saying we're allowed to split the PTO allocation, front load full-time, but accrue the part-time?
Yeah, you don't, you can treat, like I said, with exempt employees, a lot of employers are just gonna front load, and with their hourly employees, they might accrue. You can, as long as you're abiding by the act, you don't have to, the act doesn't require that you, that every employee be treated the same. It requires that every employee receive 1 hour per every 30 hours worked. So, now the problem is, I think you have a natural split, you have a natural kind of difference between a part-time employee and a full-time employee. So you might just say, this is our part-time employee policy and this is our full-time employee policy. What you don't want to do is treat people differently where someone can say, wait a minute, I might be part-time, but I'm also the only woman and I'm the only one who's getting split this way. You see, this can kick you into the other discriminatory protections. So you need to be careful about how you're doing it, obviously.
I thought you were required to allow usage in the smallest increment allowed by your payroll system. Is that not correct?
I thought it was
Well, it has to
payroll
do
system.
with
Let's see.
how you account for absences or
Right,
use of other time.
right.
Yeah, so if you're tracking your time in 0.1 or half days or full days, that has to correlate with how the employees are able to take their time off.
It's basically that, I believe the act is how you make your other leave available. So if you, like I said, if you require someone, if you require employees to take a full day when they take a PTO day, then you can require them to take a full day when they take. Now, the tricky part is, what if they haven't accrued a full day, right? So you might give them part of, or you can let them take a full day and pay them for the hours that they were accrued and not pay them for the other hours.
If you offer 80 hours annually, are you required to post ESTA DLEO?
poster?
Yes,
Yes.
yeah, the posting requirement is required. I thought you were putting us in a foreign language there for a second, and I figured out what you were doing there, so.
What about subcontractors who work like an employee on a 1099 basis?
That's the gray area. Let's go back to that definition of employee. You tell me. Is that person engaged in service to you in the business of in your business, right? I think that we're gonna see a lot of activity around independent contractors.
Can everyone's anniversary date dictate their renewal date, or do we have to pick the same date for everyone employee's hours calculation?
I think you have to use the same year for everyone, whether that's your calendar year that you use for other leaves or, policies, or whether you use a July to June fiscal year, like some companies might. You have to, yeah, it's within it's within that work year. Lori's question there, no, Lori, you do not have to pay out ESTA on termination. You can if you want. That actually, I will tell you this. The wage and hour division will say, if you have a policy of paying out PTO and it's a written policy, an employee quits, you have to pay the employee. I've litigated that with the wage and hour division before. Where we won it because the employer did not have a written policy. But if you have that written policy, then yes, you're gonna have to pay out ESTA as well. Is that it?
Yes.
That's 9:55, Greg. We're right about at that time that you wanted, I think.
It was perfect. Appreciate that. I was just writing down a few things to let everybody know at the end. The presentation, we plan to email, so we'll be emailing a follow-up to everyone who registered, regardless if they're here. We're going to email the presentation and the recording. We're going to make sure that Ron, Jill, and Jeremy's contact information is in there. And then as they follow up on, I think there were at least 2 or 3 questions. Once they get that information to us, we can also then send that out to the registration list as well as here's a follow-up to a few questions to clarify some answers, and we'll get that information out. And you can also, if you think of different questions, you can always email us at ABC. You'll have our contact information in that email follow-up as well. And so we're happy to dig in and find some information. And if we have to do another webinar on different topics as guidance comes out, we will. I want to thank Ron and Jill and Jeremy and the entire Hilger Hammond team for taking time to educate our membership and the attendees today. So have a wonderful rest of your day. And thanks again. We'll follow up soon.
Thanks, Greg.
Thank you all.